The court responds, the Article 2 executive branch of government, the elected president, elected by the whole of the people to carry out their political will, an independent branch of government, asks this unelected, black-robed, tyrannical, inferior district trial court Judge Paula Xinis to extend the deadline, the 9:30 a.m. deadline, arguing that they require several days to meaningfully review the Supreme Court's decision, issued last night at 7 p.m. So the Supreme Court decision was 7 p.m., and her order to report to me by 9:30 a.m. tomorrow was hours after 7 p.m. By the way, you think it's normal for federal judges to be issuing orders in the late hours of the night? Not just people to respond, ordering an executive branch, the Article 2 executive branch, independent branch of government, to respond to her and her needs. If you're ever compelled to use force in defense of yourself or your family, the good news is that if you defended lawfully, you can be very hard to convict. But did you defend lawfully? Because if you don't know where the actual legal boundaries for self-defense are, it's the easiest thing in the world to innocently step over them, and now you're extremely easy to convict. Good news. In just a single day, you can become an expert on the law of self-defense and make yourself extremely hard to convict. On Saturday, April 26th, I'm holding one of my only twice-a-year full-day law of self-defense advanced classes. This class is taught live by me and live streamed to you. It teaches you everything you need to know in one day, and there's plenty of opportunity for personal Q&A with me as well. Even more good news, when you register today, you save yourself 50% off the standard registration, but that discount ends soon. Your 50% discount and many more details on this advanced class are available just by pointing your browser to lawofselfdefense.com/advanced today. And I'll also drop that link in the description. I look forward to seeing all of you there. The Supreme Court entered its order after business hours last night, and this court's amended order followed several hours later, so later in the night. The initial deadline contained in that amended preliminary injunction, 9:30 a.m. the next day, requires the White House to provide the court of this unelected black-robed tyrannical district court Judge Paula Xinis with a plan for diplomatic engagement with a foreign sovereign nation a mere 30 minutes into the business day, following the Supreme Court's decision last night, and is, check this, Judge, inconsistent with the Supreme Court's instruction that this unelected black-robed tyrannical inferior district trial court Judge Paula Xinis clarify its directive to effectuate the return of this MS-13 terrorist with due regard for the deference owed to the executive branch in the conduct of foreign affairs. Now, I will grant you, you don't normally speak to a judge like this, a judge presiding over a proceeding in which you're representing a client. But this judge's conduct in setting these midnight deadlines, these 9:30 a.m. the next day, all of these are the next business day deadlines, is outrageous. And she's already been checked by the Supreme Court, and then she misrepresented what the Supreme Court said about her zaniness. She characterizes it as the Supreme Court affirmed my Friday evening order. No, they didn't. They checked it. They said facilitate may be okay. Effectuate is not. So how does the judge respond to this? Well, first of all, she gets petty. So this is document 52. Let's go back to the docket. What does the docket say about this? Let me pull it back up again. This request for more time on the timetable, all this has to be drafted and submitted to the court on the deadline that the court set, 9:30 the next day. So the judge gets this document 52, asking for more time. Back to the docket here, the official docket for the court. There's 52. And the judge doesn't like the way it was filed. Regarding document 52, motion for extension of time, it has been noted as filed in error. And the document link has been disabled. Actually, the document link still works. That's the document I just showed you, where the White House is asking for some more time, more than half an hour. The name of an attorney who e-filed the motion does not appear on the document, and the attorneys whose names are on the document are not admitted to the Maryland Federal Bar, nor have they been granted a special appearance. An attorney may not e-file a document on behalf of another attorney. What's really happening here? These are the attorneys who filed that request for the extension. They are all admitted to argue this matter before this unelected black robe tyrannical federal district court Judge Paula Xinis. All of them. But because they were in such a rush, they had a subordinate hit the computer keyboard button to e-file the document. That subordinate's not appearing before the court. They're not making a legal argument. They may as well have had a legal secretary do it. Except when you e-file, it's supposed to be a lawyer, and the subordinate they chose isn't really part of these proceedings, was just doing an administrative task, the e-filing. Unelected black robe tyrannical inferior district trial court Judge Paula Xinis chose that to make a docket entry over, an official record of the proceedings of this case. It's hard to imagine anything more petty than this. Of course, Abrego Garcia, his team, doesn't like the deadline, doesn't like the request for an extension, I should say. They have all kinds of whiny complaints about it. They say all we're asking for, all the court ordered, was for the White House to be prepared to share what it can concerning the steps it has taken and the prospects of further steps. Isn't half an hour enough for that? Isn't half an hour enough? So the defendants propose a modified schedule. We already talked about that. And the judge responds. She responds with insanity, with madness. This is like having an argument with one's ex-wife. It's insane. The court responds. The Article 2 executive branch of government, the elected president, elected by the whole of the people to carry out their political will, an independent branch of government, asks this unelected, black robe, tyrannical, inferior district trial court Judge Paula Xinis to extend the deadline, the 9:30 a.m. deadline, arguing that they require several days to meaningfully review the Supreme Court's decision issued last night at 7 p.m., so the Supreme Court decision was 7 p.m., and her order to report to me by 9:30 a.m. tomorrow was hours after 7 p.m. By the way, you think it's normal for federal judges to be issuing orders in the late hours of the night? Ordering people to respond by 9:30 a.m. the next morning? Not just people to respond, ordering an executive branch, the Article 2 executive branch, independent branch of government, to respond to her and her needs by 9:30 a.m. the next day, filing that order in the late hours of the night. That is not normal. This judge is not normal. This judge is mad. They say it's impractical for defendants to comply with the court's 9:30 a.m. deadline only a few hours after the court issued an order in this case. They say this supports the extension of the filing deadline until April 15th. So they're asking for 4 days. That's all. The White House is asking for 4 days. But don't worry, Paula Xinis has this in hand because the unelected black robe tyrannical inferior district trial court judge rejects this request. She writes, the defendant's act of sending Abrego Garcia to El Salvador was wholly illegal from the moment it happened. That's not true. That's not true. It wasn't wholly illegal. It was at worst an administrative error. And if the executive branch were deporting Abrego Garcia today, they would send him right to CCOT because he's a designated terrorist and he doesn't get the benefit of withholding deportation to El Salvador. It's not wholly illegal from the moment it happened. He was a terrorist when he was deported to CCOT the first time. Indeed, and then she quotes the Supreme Court's characterization of the White House position. This has never been said by the government, by the executive branch. They've never conceded this, but she quotes it as if it were true. A big mistake by the Supreme Court to mischaracterize the evidence in this way and provide an opportunity for inferior, unelected, black-robed District Court Judge Paula Xinis to exploit that mischaracterization of the facts deliberately. The United States, the Supreme Court credits The United States acknowledges that Abrego Garcia was subject to a withholding order forbidding his removal to El Salvador, and the removal to El Salvador was therefore illegal. The White House doesn't say it's illegal. The White House says at worst it was an administrative error. She doesn't quote that part of the Supreme Court decision, where the Supreme Court acknowledges that. They do merely say it was an administrative error. Second, the Article 2 executive branch's suggestion that they need time to meaningfully review a 4-page order from the Supreme Court that reaffirms this basic principle. What basic principle? The mischaracterization of the facts? Blinks at reality, she says. Oh, she blinked. Third, the Article 2 executive branch misconstrued the Supreme Court's order stating that the original deadline is no longer in effect. They explicitly said it was no longer in effect because it had passed. How could it be in effect? How could the Monday midnight deadline still be in effect for purposes of a Supreme Court order issued on Thursday? Obviously, it's not in effect. Nobody has a time machine, Paula Xinis. Not even unelected, black-robed, tyrannical, inferior district trial court judges. Not even they have a time machine. As the Supreme Court plainly stated, the government should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. The Supreme Court didn't say by 9:30 tomorrow morning. You said that. You set that deadline. And then denied the White House a mere 4-day extension. But don't worry, Paula Xinis is not completely heartless, not completely mad. Okay, she set a 9:30 a.m. deadline. She'll adjust it. The unelected, black-robed, tyrannical, inferior district trial court judge, Paula Xinis, will extend her 9:30 a.m. deadline to 11:30 a.m. Congratulations, White House. You get an extra 2 hours to engage in foreign negotiations. So the White House responds. Here, they say, well, thanks for the 2-hour extension, but we're unable to provide the information requested by this unelected, black-robed, tyrannical, inferior district trial court judge, Paula Xinis, on the impractical deadline set by her hours after the Supreme Court issued its order. The Supreme Court's order directs the unelected, black-robed, tyrannical, inferior federal district court judge Paula Xinis to clarify its directive with due regard for the deference owed to the executive branch in the conduct of foreign affairs. How much deference is a 30-minute deadline, then extended another 2 hours? Is that deference to the Article 2 executive branch management of foreign affairs? It would seem not. And the Supreme Court ordered Paula Xinis to clarify what she means by facilitate or effectuate, which she did not do. She merely took away the word effectuate, but she doesn't say what facilitate means. We know what facilitate normally means. Normally it means raise no barriers on our end to reentry. But she's ordering that the White House return Abrego Garcia to the U.S. That's not facilitate. That's effectuate. So she took the word effectuate out of her order, but the order is still to do the thing that requires effectuation. By the way, a preliminary injunction has to inform the enjoined party of precisely what they are being ordered to do or not do. A preliminary injunction that is ambiguous is without legal effect. How can it be when the other party, the party being enjoined, lacks clarity on what they're supposed to do exactly or not do exactly? That's why the SCOTUS required clarification, which she did not provide. Defendants request, and they get a little snarky here, and require. We require. Guess what? Unelected, black-robed, tyrannical, inferior district federal trial court judge Paula Xinis. We have authority too as the Article 2 executive branch. You're not the boss of us under our constitutional order. We can make demands too. We have core and plenary powers, perhaps no higher than in the management of foreign affairs and national security, which is why Kilmar Armando Abrego Garcia was deported to CCOT. He has been designated a terrorist for more than 6 years. designated a member of MS-13 for more than 6 years, and MS-13 is now designated a terrorist organization. And we, the White House, has core and plenary authority to deport a designated terrorist anywhere we want, including CCOT. And what we may have promised someone before they were a terrorist doesn't apply anymore. They've graduated. They got their certificate. They are now a terrorist. Congratulations. We're sending you to a resort in El Salvador. The White House, the executive branch, requests and require the opportunity to brief that issue. In other words, explore, analyze that issue prior to being subjected to any compliance deadline. Needless to say, the executive branch is under no obligation to take action under the court's order while it was stayed by the Supreme Court, paused by the Supreme Court. In light of the insufficient amount of time afforded to review the Supreme Court's order following the dissolution of that pause, the executive branch is not in any position where they can share any information requested by the court. That is the reality. You unelected, black-robed, tyrannical, inferior district trial court Judge Paula Xinis. That is a reality that places limits on your authority. Get in your lane. The Article 2 executive branch received the modified order late in the evening last night, demanding we respond by 9:30 a.m. We are reviewing the order, actively evaluating next steps. It's unreasonable and impracticable for the Article 2 executive branch to reveal potential steps before those steps are reviewed, agreed upon, and vetted. Foreign affairs cannot operate on judicial timelines, in part because it involves sensitive, country-specific considerations, wholly inappropriate for judicial review. You, unelected, black-robed, tyrannical, inferior district trial court Judge Paula Xinis, do not have authority over everything. There are things that are outside your authority, and included among those things are matters of foreign affairs, inappropriate for judicial review. Paula Xinis has no more authority under the Constitution to review the foreign affairs decisions of the Article 2 executive branch than she has to tell me what paintings I can hang in my house. So what does Paula Xinis do then? She goes even crazier, all in the same day. We're still in yesterday, folks. We're still in yesterday. All this is happening yesterday. Order from the unelected, black-robed, tyrannical, inferior district trial court Judge Paula Xinis. For the reasons discussed in today's status conference, so she had these people appear in her court to speak with her in person, and then she sealed the transcript of that. So I can't get it. Nobody can get it. It's sealed. We're going to show that here. Let's see. Here. Item number 60. Immediately preceding this order. This is docket entry 61. Docket entry 60. Status conference held on April 11th before Judge Paula Xinis, unelected, black-robed, tyrannical, inferior district trial court Judge Paula Xinis, sealed on Pacer. Pacer being the online docket access platform. This platform I'm using sucks data from Pacer. Pacer itself sealed it. I can't get it. What happens if I click on that button? Nothing. So there's no transcript accessible to the public about what was said in that meeting. All we do get is this new order. Where is it? Here it is. Do I have that up? Yeah. So, for the reasons discussed in today's status conference, which I ordered sealed, the unelected, black-robed, tyrannical, inferior district trial court Judge Paula Xinis finds that the Article 2 executive branch has failed to comply with this court's order, the one issued the night before, in the late evening, hours after the 7 p.m. Eastern Time SCOTUS order was issued. The unelected, black-robed, tyrannical, inferior district trial court Judge Paula Xinis had ordered the Article 2 executive branch to file a supplemental declaration from an individual with personal knowledge, giving the current physical location and custodial status of Abrego Garcia, what steps, in any, the Article 2 executive branch has taken to facilitate his immediate return to the U.S., which SCOTUS did not order his return, only his release, to facilitate his release, not raise barriers to his release, not effectuate his release. And what additional steps the Article 2 executive branch will take to facilitate his return. Again, facilitate his return is not in the Supreme Court order. She is making this up. She's pretending she has this authority. She writes, the Article 2 executive branch made no meaningful effort to comply. Well, not within your 30-minute deadline. Instead, the Article 2 executive branch complained. It's a complaint. When the Article 2 executive branch is asserting its core and plenary constitutional authority, she characterizes that as a complaint. Instead, the Article 2 executive branch complained that my zany order is unreasonable and impracticable and involves sensitive country-specific considerations wholly inappropriate for judicial review. During the status hearing, that I, the unelected black robe, tyrannical, inferior district trial court judge Paula Xinis, ordered sealed, I posed straightforward questions. Where is Abrego Garcia right now? What steps has the Article 2 executive branch taken to facilitate his return while the court's initial order on injunctive relief was in effect from the evening of April 4th, 2025, through the morning of April 7th, when it was paused by the Supreme Court, and since 6:35 p.m. last night, when it was relieved of the pause by the Supreme Court? The Article 2 executive branch responded he cannot answer these questions, and at times suggested that the Article 2 executive branch, his bosses, had withheld such information from him. He's just a lawyer. And by the way, this judge is not entitled to these answers. These are outside her authority. As an unelected black-robed, tyrannical, inferior district trial court judge with zero constitutional authority to interfere in foreign relations. Counsel could not confirm and thus did not advance any evidence, any answers to my questions. Well, you're not entitled to those answers, Judge. You're overreaching your authority. This remained the executive branch position even after this court reminded them that the Supreme Court expressly affirmed this court's authority to require the government to facilitate Abrego Garcia's return. This is a lie. We looked at the SCOTUS decision. I broke it down in detail yesterday. We looked at it today. The SCOTUS order does not say facilitate Abrego Garcia's return. It says facilitate Abrego Garcia's release from custody. That's not the same thing. It's not the same thing. To facilitate his release from custody, which is meaningless. That only means that the U.S. government would not raise obstacles to his release from custody. That's not within American control. Oh, what obstacles are they posing? They don't have any authority over CCOT. So facilitate release from custody is meaningless, and it certainly does not say facilitate his return. That's not in the order. That is a lie. A lie from a federal judge on the bench. A lie to compel the Article 2 executive branch to jump at her command in areas of law over which she has no authority, foreign affairs. From the perspective of this unelected black-robed, tyrannical, inferior district trial court judge, the Article 2 executive branch's contention that they could not answer these basic questions, absent some non-specific vetting that has yet to take place, that's why they wanted 4 more days, Your Honor, provides no basis for their lack of compliance. And this is how petulant she gets now. Accordingly, it's ordered that beginning April 12th, the next day, today, Saturday, and continuing each day thereafter, I am ordering, an unelected black-robed, tyrannical, inferior district trial court judge, is ordering the Article 2 executive branch, an independent branch of government, to appear before me, or at least file a document every day by 5 p.m., a declaration made by an individual with personal knowledge of the information asked for, the current physical location of this MS-13 terrorist, what steps they've taken to facilitate his immediate return, which is not required by the SCOTUS order or any law, and what additional steps they will take to facilitate his return. A follow-up in-person hearing will be scheduled for Tuesday, April 15th. Petulant. Absolutely petulant. Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.